afternoon, everyone. My name is Sophie Capo-Bianco. I'm a senior associate here at Expatriate Law, and I'm joined by Veronica Dindo, who's an Italian lawyer based in Verona. Hi, Veronica. How are you today?
Hello, Sophie. I'm very well. How are you?
Yes, very well, thank you. Thank you very much for giving us your time today. I know how very busy you are, and you've just set up a new law firm, which is very exciting. So if you'd like to introduce yourself and tell us a bit about your new firm and the nature of your work.
Yes, sure. So I'm Veronica Dindo, a lawyer based in Italy, Verona. I mostly take care of family law and estate planning in my practice, and I'm also interested in, especially in international family law. I've started my own practice, since a few months, and it's very exciting. So thanks for inviting me here.
Excellent. Oh, well, I wish you and your and son, you've set it up with a colleague, so I wish you both the very best and look forward to hearing all the developments about it. So just have a few questions for you today, just about the local laws for you in your country in Italy. So my first one is, can British expats living in Italy divorce in your country? And if so, for how long do they need to have been living in your country for?
The answer is yes, they can. But preliminary, in order to properly give the correct answer, we would need to check the rules of international private law that discipline those kind of cases where there is an element of a foreign element, we could say, such as the example you provided. Italy applies the European regulation, and this applies also towards those citizens that are coming from countries that do not belong to the European Union, such as English, for example. So let's say the main criteria is the one of the habitual residence. And therefore, if two British lived in Italy, and we could say that they have their habitual residence in Italy, yes, they could resort to the Italian judge. When can we say they have the habitual residence? The habitual residence is a notion that is not defined by the regulation. So there's case law from the European Court of Justice that helps define it. In general, we could say that the habitual residence is the place where a person wants to establish their life. So they set that place as the center of their life. So you need to see elements of fact, such as where is the family, if you work there, where do you actually stay, in which country. Yeah. And there's no, time can be an element of evaluation, but there's no predetermined period of time set out by the law. So, of course, if it's 2 days, it's something. If it's since 2 years that you moved, it's something else. But still, for example, if you moved your family, children started school yesterday, you moved jobs, even 2 days, could reflect what the situation is in reality.
Yeah. Okay, interesting. So it's kind of about the intention and how long you wish to be there for.
Yes, also the intention, facts and intention, and if they reflect the intention.
Okay.
Yes.
Wow, really fascinating. Okay. So my next question is then, how do the courts in Italy approach dividing assets when parties are divorcing?
Well, this is an interesting question, because it gives me the chance to point out something that might be different from other systems. That is, when there's a divorce case in Italy, the patrimonial aspect focuses on maintenance, mostly. The division of assets comes to the attention only if the parties are in a patrimonial regime that is the communion of goods. this is the case where the court needs to, if there's no agreement between them, decide over the division of assets, because otherwise, if they opted for separation of assets, I mean, they might not have common assets, or if they have common assets, it's because they bought them commonly, okay, jointly, okay, so, but this is not necessarily for something that happens to married people. It could be two friends, so it's not specific of the divorce case. It's something, okay. So, and this is just to, preliminary point out the Italian approach. If we go back to the case of the two British nationals, for example, we would still need to preliminary ask ourselves the question, who is the judge and what is the applicable law, which is something different. Okay, in general, again, here we apply the EU regulation, and again, it applies no matter the nationality of the interested parties. Always, in general, let's say that jurisdiction, there's a rule saying, there's a prescription that says that when there is jurisdiction for the claim related to divorce, the statute, then there is jurisdiction also for a claim regarding the division of assets, the patrimonial claim. With regard, on the other hand, to the applicable law, the regulation gives the possibility to the party of choosing the law they want to apply, but with some limits. For example, they need to have a connection with this law, for example, to be citizen, at least one of them, of the country of the choice of law, of the law chosen. So either they choose it, and this is also important to notice, is that the choice has effects from today on, so from when it's made onwards, okay? If there's no agreement, then there's a criteria to determine the applicable law that are the first common habitual residence of the spouses from the day of the marriage, or the common citizenship at the time of the marriage, or the state where to which they have the more strict connection. Those are the criteria. Yes. Okay. It's complicated, but
well, that's fascinating though, that they can either elect to choose or if they can't choose, then it will be the judge then who then decides, will they? They'll look at the facts of whether it should be Italy or, for example, England, and then they'll make that ruling, will they? Yeah. Okay. Okay, so then my next question is regarding maintenance. So is spousal maintenance awarded in your country? And if so, for how long? Like, do you have X amount of years? Is it related to for how long the marriage is?
Well, yes, it is awarded. There are requirements, and there's also a difference between the separation, the case of a separation and a case of a divorce. Yes. In general, we could say that the maintenance awarded in case of a separation has as a parameter the life standard that the spouses had during the marriage. While in the case of a divorce, the requirements are more strict. This is a case law pointed them out. Right. Basically, there are three main parameters. First, there must be a difference between the economic capacity of the spouses, a relevant difference. Secondly, this difference must have been caused by the sacrifice of one of them in the name of the family. So, for example, in order to bring up to take care of children, I quit my job. And thirdly, the one that had to do the sacrifice is not able with their own strengths to overcome this gap. Okay, so you need, I mean, those three parameters, requirements need to be matched in order for the court to grant a maintenance towards the one that requests it. And it's in general a problem of proof because it's not so easy to while on the other hand, I mean, so also the quantity of the maintenance then is parametered to this, the ability to give such a proof, and also to the length of the marriage. While in the case of separation, as I said, it's the life standard, and also the fact that one is somehow in need and has a weaker capacity, we could say. So it's a bit different. And with regard to the fact of the limiting time of the maintenance, no, this is not something that is normally, I mean, it's not prescribed by law. The counterbalance to it is the fact that if some occurrence happens subsequently, then the parties are entitled to, each one of them, to resort to court in order to request a variation. For example, if the stronger spouse, the one that is paying the maintenance, loses their job, then they could resort to court for the termination of the, of the maintenance, or an increase in case there's some improvement in the capacity. Okay.
Yeah, that sounds quite similar to English law then, that we can have this variation of maintenance, because it's so variable, isn't it, as a sort of provision in the settlement. And I always find it the trickiest point of negotiation when it comes to a financial settlement, because the breadwinner always, doesn't want to pay much, or if anything really, to their ex-spouse, and the more financially dependent person may require or want more than what they're, entitled to, under English law anyway. I always find, that's when sort of a lot of tension can come into the negotiations.
Yes.
I think that's probably a global issue.
Yes.
not just limited to England. But, yeah, okay. For that. So another question then, going back to sort of the assets in general, are there any rules in Italy in terms of excluding assets in divorce? So if a party has inherited assets, or, they've pre-acquired assets before they got married, so pre-matrimonial, are they included within your financial settlement, or can they be easily excluded?
To answer this question, we need to go back to the previous scenario, that I tried to give. That is, when we have a divorce, we speak about maintenance. Sometimes maintenance is not paid. It could be paid in a solo solution. Okay, so all in once. And so this is a settlement that also impedes the possibility of requesting for more or for a variation afterwards, if there's a lump sum. On the other hand, we have the division of assets that takes place basically if there was a communion of good regime, patrimonial regime. So when we speak of goods that are excluded from the joint property, we need to picture a scenario of communion of goods, where, in general terms, basically all purchases that are made even individually by the spouses become joint. Okay, so if I buy a car, it's automatically my husband's as well. And also incomes basically incomes fall, we say, in the community for what remains at the time when the community is terminated. So when I get a separation, what I have in my bank account falls and has not been used to live, for example, that falls into the communion, okay, at that point. So this is just the main elements of the communion. All this is true with the exceptions of the so-called personal goods that are in fact inherited goods, donated goods, also goods that were acquired before the marriage, or goods that are strictly functional to the profession. For example, I had a case where the office bought by a lawyer was considered to be a personal good because it was strictly related to the profession, no? In order to, yeah, okay. Yes. So.
Interesting. And so was that acquired before marriage?
No, actually, no. No, it's not because it was acquired before, but because there's this prescription that establishes that the goods that are strictly functional for the profession are excluded from the communion. Oh. So maybe if you imagine, now I don't know, I'm a painter, so you know, colors and sticks to paint. That is, you know, it's more immediate to understand, you know, that they are excluded from the communion because they need them to work. It's not.
Oh, okay.
But the office for a lawyer is also very important. Mm-hmm. Now we have a remote working, so maybe a laptop, but yes.
Wow, yeah. That's really, okay, fascinating. Because in English law, that would be considered, you know, part of the pot. If someone had a business and that was, you know, built up during the marriage, potentially the spouse whose business it wasn't could have a claim, you know, against that business.
Yeah, yes, that's true. I mean, this is a very peculiar example I made. Mm-hmm. We also have a regulation regarding communion and running a business, actually. Right. Yes. Okay. Now, I mean, it's quite peculiar. I mean, there's various hypotheses. So if you started a business together or on your own before or after the marriage, if you put goods in it or not. So yes, I mean, it's something that is also contemplated by the Italian law. Mm. It varies on a case-by-case basis, but yeah. there is a regulation that predetermines all the examples. Yes.
Okay. Right. Okay. So my final question then is to do with the children. So in terms of sort of child arrangements with once parties have separated, is there a starting point in Italy of who has custody, who has contact, or is it considered sort of a shared care arrangement? What is it?
So, yeah, I would say the starting point is shared custody. Mm-hmm. With custody, I mean decisions, ability to take decisions for the children. So it's not where the children live, but the ability to take decisions for them, for school, health, I don't know, IDs, all those kind of decisions. Yeah. So it's shared not by default, but it's the more, I mean, seen with more favor from the law, mm-hmm. And only in cases one of the parents is inadequate, then it could be a solo custody, exclusive custody, we call it. Right. Something else is, of course, related, but it's not the exact same thing, where the children live. Yeah. I would say preferably, I mean, normally courts, if they need to decide over this, they will not establish a 50-50 regime because it's believed that children are not protected if they have to sleep 1 week in one house, 1 week in another house. So if parents agree over this, then I mean, they would allow it, but the court will not take such a decision. Normally, there's one parent with whom the child in the majority of the time live, and then there's a visits regime, rights to visit that are also like wide. It's not something like only once every 2 weeks, but still there's a prevalence of one of the parents. Yes.
Mm. And is that sort of automatically drawn up within the sort of divorce and financial arrangements? So in England, we have a no order principle when it comes to child arrangements. So if the parents decide between them, then that's fine. But if it comes to a stage where, you know, there are sort of fierce disagreements about where the children should live, then they make the sort of arrangement order. But is it sort of drawn up in an order in Italy, sort of alongside the financial, or?
If there's an agreement about children arrangements.
Yes.
Yes, normally those kind of petitions can be filed in one only proceeding, where there's the file for divorce, for maintenance of the spouse, arrangements for the children, and maintenance of the children. And this could all be converted into a consensual proceeding. So if they find the agreement during the course of the proceeding, then they can just submit the agreement to the court, and the court will validate it. Also, they could, it could be a consensual one from the beginning as well, if they just submit the petition that is a joint one with an agreement, and then the court will validate it.
And sorry, I've got actually just a quick new question as well. Just in terms of children then, do you find, or have you had many experiences with a lot of abduction cases filed in the Italian courts? You know, now the world is very much becoming more international, sort of year by year, and families, you know, moving around. You know, is abduction, you know, sort of a big concept in Italy? So,
well, yes. I mean, I've had cases, and it's now growing and more common. I mean, it's not, fortunately, I mean, it's not, you know, that every couple with a foreign element runs this risk. But I've seen abduction cases, and also requests for relocations, for example, because normally when the parents break up, if one is not living in Italy, they have a desire of going back to their own country. Sometimes they do it illegally, taking the child and going. So I mean, yes, it is a reality.
I think, sadly, as you know, I think it probably is, you know, very much a global issue, isn't it? Just with the way the world's becoming more international these days.
Yes.
Okay. Well, Veronica, that was so fascinating. Thank you very much. That's all the questions from me for today. That's been so helpful, and just been really enjoying learning about the Italian laws to do with families. So thank you so much for your time. We're so appreciative at Expatriate.
You're welcome.
It's been great. And yes, if we get any Italian referrals, then I'll be sure to send them your way. It sounds like you're pretty busy as it is at the moment, but I wish you all the best with your new firm as well.
Thank you.
Very exciting, starting a new chapter. But that's it from me, so thank you very much.
Thank you, Sophie, for inviting me. I enjoyed the sharing.
Excellent, thank you. Take care, bye.
Bye-bye.